I'm Nikki Jovicic from LookUpStrata, and for today's webinar session, I'm joined by Munstermann from QIA. In this webinar, we're talking about the new WHS legislation due to commence in WA during 2022. Before we begin, I'd like to mention that the information contained in this session, including the discussions that arise from submitted questions, is not legal advice and should not be relied upon as legal advice. You should seek independent advice before acting on the information contained in this session. Very shortly, we will be joined by Munstermann from QIA. Marcus is a foundation member of QIA Group and Chief Executive Officer and has been involved in the strata industry for over 20 years. He has a wide and varied working background in the property industry, working in land sales, real estate, project marketing, as a building manager with management rights with over a 94-lot scheme, and specific experience in body corporate management and consulting. He holds qualifications in business administration and workplace health and safety. Welcome, Marcus. Thanks so much for your time and for joining us today.
Thanks for inviting me along. Just wanted to say hi to everybody. Hope you're all safe and well. I just wanted to talk to you about the new legislation that's coming in. Essentially, it's an extension of safety legislation that's been working its way through from harmonised legislation that they established in about 2010, 2011. So each of the states have slowly but surely been adopting it. Up until only very recently, we've been checking the website and looking to see when the regulations will come into force. Unfortunately, we haven't seen too much more information about that. Sometime this year is the latest sort of thought, but regardless of that, it's a good time to actually talk about it because there are certain changes that will need to be introduced, and it might be a great time to start talking about what it'll mean for strata companies going forward. So I think the first sort of thing that I like to go over are just some key reference terms. So these will come up quite a few times. We talk about common property. I'm assuming everybody understands what that means. So in a plan of subdivision, you have lots, and then you have the balance of the property, which is the common property. And then a strata company, which is essentially a body corporate that is incorporated by registration of a plan of subdivision. Then there's a duty holder. I think that's a very important term. That'll be a determining factor as to whether the new legislation applies to you or not. Another very important term will be person conducting a business or undertaking. The shortening of that is PCBU. Then there are other persons at the workplace. And then there's workplace itself. So other persons at the workplace are people that are actually, they might be the customers, they might be visitors, they might be owners that are actually there when work is being done, and they'll have responsibilities as to how they either conduct themselves or telling contractors about things that they're aware of. And then there's workplace itself. And we'll go through the various parts of the legislation and then just talk about, I suppose, firstly, what the legislation is, what it intends to do, how strata companies will be impacted, and then the practical application of the legislation, how they might actually discharge any obligations that they have going forward. So essentially the vibe of the thing is that you have as a strata company, you have a property that consists of lots and common property. The lots are essentially left up to the owners in terms of maintenance and as to the standard of maintenance. So they set their own boundaries as to what they deem to be acceptable for that. Then there is common property, and that becomes a little bit more problematic. Mainly because a lot of owners don't necessarily know that there is a standard to which to maintain the common property, how they should go about doing so, funds involved, when they should do it. Those are the sorts of things that we'll discuss to a certain extent. and see if we can clarify that as much as possible. And then there are also other pieces of legislation or standards or codes that impact on strata companies that sit outside of work health safety legislation, and they're also important for their own reasons. So strata companies need to be aware of quite a large range of differing pieces of legislation, which we won't touch on too much today. There might be things like disability and discrimination legislation, fire safety or dangerous goods legislation as well, that will impact upon a lot of strata companies. So that's, I suppose, generally the vibe. The safety framework itself, for most strata companies, will consist of building codes and standards, and inbuilt into what they call the National Construction Code is a minimum required level for safety, health, amenity, accessibility, and sustainability. So health and safety starts at the building level and the construction level. So there's a lot of thought that goes into how high stairs are, whether they have a handrail, whether you need a sprinkler system, that's based on the number of floors that you have. All of these sorts of things are built in, and they provide a great deal of safety in the first place. So that's important to understand, particularly if you go to modify things. You might upset the approvals of the day and might come under current approvals, and you might need to get advice as to anything that you do going forward as well, particularly if it substantially modifies or upgrades something that you've got in place. Then you've got the Strata Titles Act itself, which talks about keeping the common property in serviceable repair, and to ensure that you renew and replace the common property, the fittings, the assets that you have. So there's a certain amount of safety built into that in the first instance as well, because the strata company has essentially one job, and that is to manage and maintain the common property. And if you do that job well, the body corporate stays safe, or the strata company stays safe. If you do that not so well, then you expose yourselves to risks. And I suppose that's the key element as to what a strata company does, and how it will be impacted by the work health safety legislation. Then there's the Work Health Safety Act and regulations. They very much focus on the health and safety and welfare of workers and other people who might be affected by the work. So it's quite specific in terms of how it's going to be applied. It doesn't necessarily deal with, say, the broader issues of, has my property been built safely? I have concerns about my security or well-being when walking through a car park. Those sorts of things have very specific applicability for employers, employees, and workers that you engage on certain terms. But outside of that, they don't. So again, we'll try and boil everything down to what strata companies are going to be involved with as we go forward. And then there are going to be duty holders under the legislation itself. And I suppose that's key as to deciding what it is that you need to do. So in practice for strata companies, buildings are built to an accepted standard of safety. If they're maintained over time, they maintain that standard of safety. And then workers who carry out maintenance works are not exposed to harm in the maintenance process as well if you've maintained your common property. And in that context, this is where we need to see where the strata companies come into the frame. So the new laws themselves, we go from a regime where you have employers, employees, and self-employed persons. And each one of those duty holders under the old legislation attracted certain duties and obligations. That's now being replaced by an overarching duty holder, which is called a person conducting a business or undertaking. and they essentially what it's supposed to do is capture a very broad range of businesses, undertaking, stretching from volunteer right through to government workers and to some extent mines. So it's a very much broader definition of a duty holder. And then duty holders, so the person conducting a business or undertaking has a primary duty of care, which is so far as reasonably practicable to ensure the health and safety of workers and others who may be affected by carrying out the work. So that's the quite a large shift from what was there previously. That primary duty of care is quite involved and requires a lot more certainty from the persons that actually own and run the business in terms of whether it's safe or not for their employees and people working in that business. So they need to engage in what they call due diligence. So it's a very proactive framework whereby I ensure, or I assure as a boss, that all of the practices that I'm undertaking are safe for my workers. I can't just assume that they're the case and that the workers are actually undertaking that work. So I suppose key points for strata companies is, we'll go through these, is do they have a workplace? That's important to whether the Work Health Safety Act is going to apply. Are they a person conducting a business or undertaking? That's important because that's one of the main duty holders. What kind of business or undertaking they might be presumed to be, and then do they manage or control workplaces? Do they have officers or workers? And officers and workers is also a key point because when we have committees, they are officers of the strata company. So does the duty holder of officer apply in this circumstance to a strata company? So in the first instance, strata companies do have a workplace, and that's the common property when works are being carried out upon it, essentially. So they need to engage contractors to undertake the maintenance work. That then means that the common property becomes a workplace at that time. So that's the first point. Yes, they do have a workplace. The second point is a strata company a PCBU, so a person conducting a business or undertaking? And the Act itself under Section 5 says a strata company that is responsible for any common areas used only for residential purposes may be taken not to be a person conducting a business or undertaking in relation to those premises. So the Act is being quite specific in saying that a residential strata company is not intended to be caught as a person conducting a business or undertaking. Now, that changes if a residential strata company engages a worker as an employee. So they're being very specific in the wording when you engage a worker as an employee. So not a contractor, you engage them directly as a wage earner, I suppose is a way of putting it. And in those circumstances, you become a PCBU or a person conducting a business or undertaking. Otherwise, you don't. Now, I think what's also very, very important when it comes to the question of PCBU is it's the regulator, which would be WorkSafe WA, that makes those determinations with respect to the Work Health Safety Act. So while getting legal advice is important, the people that bring prosecutions will be WorkSafe WA, not a lawyer. And it's very, very important if you want clarity to talk to the regulator because, and this will take a while, unfortunately, the new act comes in, then they'll have to put up fact sheets. There'll be discussions around the meaning of the legislation and how it's to be applied. But again, they're the people that will end up doing it, and they'll bring prosecutions based on their interpretation, not on the interpretation of somebody that sits outside of that framework. So it's quite straightforward in that the legislation says this is what it is, and these are the people that are going to manage it going forward as well. This is the authority. So I think that's important as well. In many of the other states, there's been quite a bit of debate as to whether a strata company is a PCBU or not, and that debate's, I think, finally sort of gone out after 10 years, but there's still the odd thing that pops up. But in a lot of the states, they have fact sheets. Given that the legislation in WA is going to be part of the harmonised safety legislation, a lot of the information out there in the other states will be, to a large extent, applicable to WA as well. When the regulations come in, we'll just have to sort of have a little bit more of a look at those and see where the specific differences are. But dealing with, Queensland, New South Wales, ACT, I think Tasmania, South Australia have all brought it in. Victoria's a holdout. Apparently, I've been told what they have is better. So we'll just leave them to that. And WA's come across. I think a lot of the issues with WA were specific to mining, and they wanted to make sure that they had the right sort of hold on that. The next point is to ask whether a strata company has officers. And again, they've been quite helpful here. So what they say is that an officer is an officer within the meaning of the Corporations Act. So again, if you have a look at the Corporations Act, it talks about directors as being officers and CEOs being officers. So what I understand is that a treasurer or a chairperson is not an officer under the Corporations Act. So that means that they do not attract the duties under the Work Health Safety Act because they're not an officer under the Corporations Act. And it's quite specific as well. So the thing with legislation is they are quite purposeful in the way in which they construct it. So if an act or regulation says this is what we think, that's what they intend. And a lot of the time you'll find silence in the legislation, which is a little bit more difficult to read and what I call unhelpful. But in these circumstances, with respect to the definition of a PCBU and an officer, they've been quite specific, which is really helpful to strata companies. Now, when we're talking about a strata company engaging a worker as an employee, what they've done is they've expanded the scope of worker and what's deemed to be a worker under the Work Health Safety legislation. And it includes an employee, a contractor, subcontractor, an employee of a subcontractor, an employee of a labour hire, an outworker, an apprentice, trainee, student, or volunteer. So these are all workers. The trigger, though, as to whether you're a person conducting a business or undertaking is whether you hire somebody as an employee. So not whether you hire a worker as a contractor or a student or a volunteer, but very specifically if you hire them as an employee. So I think that's very important as well. So they've expanded the overall list of people that they deem to be a worker, but then they've been very specific about saying what will break the residential exemption, if you like. So the next point, I think, which is very, very important as well, is that I think one duty that will apply to residential strata companies is the the duty of others at the workplace. And it's a little bit opaque when you read it, unfortunately, but basically a person at a workplace, so that means anyone at a workplace, and needs to take reasonable care for their own health and safety. They need to take care that their acts or omissions don't adversely affect the health and safety of other persons. So if you're aware of something when you ask an electrician to come to site, and you don't tell them, and let's just say you ask them to replace a light fitting on the 3rd floor, they walk up there, you know that there's a loose rail at the top of those stairs, they lean back on the rail, they fall. You then will have a duty that you haven't met in terms of letting them know that there's an issue there with the common property. And that comes under the duty of care as well, which is mirrored in common law. And we'll talk about that a little bit later in the presentations. And then you also have a duty to ensure that you comply with any reasonable instruction that's given to you. So if you've got a painting contractor and they're undertaking painting works and they've built a scaffold and they've protected one entry into the building, and they say to you, you're only allowed to come into the building via this entry, you must follow that instruction. If you don't, and you enter via another entrance to the building because it's more convenient to you, let's just say, and something happens to you or your guests, you've actually breached your duty of care as well in all of this, because you should have followed that instruction, because what the contractor who's trying to control the site where the work is going on is trying to do is to stop you being impacted by something that they're doing. So it's important that owners understand they have responsibilities to ensure that they follow those instructions as well. And I think that's it in a nutshell in terms of strata companies. So if you go back over it, residential strata companies are generally not a person conducting a business or undertaking. And that's the key definition as to whether the Work Health Safety Act will apply. And then they'll also have other duty holders, which are a person conducting a business or undertaking that manufactures plant and equipment, let's just say. That's one other definition. Or a person conducting a business or undertaking that controls a workplace. But it always starts with person conducting a business or undertaking. So if you don't qualify in the first instance as a person conducting a business or undertaking, then you don't qualify for the second part. So if you have a look at the current Occupational Health Safety Act, what it talks about is people that control workplaces, and it talks about employers that control a workplace. And again, most residential or even commercial schemes or non-residential schemes don't employ somebody. They're not an employer. So they're generally not caught even under the old legislation. So what they've done is clarified it to as great an extent as possible. So the one duty that seems to fall on everybody, so you have all of your duty holders, and then you have the last one that I mentioned, which was the duty of others at the workplace. And that falls to everyone, essentially, that's left over. If you like, it's the catch-all one, just to make sure that people look after themselves, understand that there might be work going on around them, to take care that they're aware of that and follow any instructions, and also tell people if they're aware of something that might adversely affect the painting contractor. If there's an unstable balcony, if windows have been a problem, in the building as well, or there's an asbestos roof or something like that. All of these things the contractor will also need to look after for themselves, but you have an obligation to tell them as much as you possibly can about what you have experienced on the common property. So it doesn't look quite as simple for non-residential schemes. So what we're talking about there is industrial, commercial, mixed use. Mixed use is going to be a little bit more tricky, unfortunately, because in the other states, it's really applied very, very specifically to those areas of common property that are used by the commercial part or the industrial part of the strata company. So it's quite specific to those sorts of areas. And again, what that would mean is that the non-residential strata companies are persons conducting a business or undertaking. And what that essentially means is that they need to ensure that the workplace is safe for people coming to it and leaving it. And we have to determine what it is that that non-residential strata company does. So again, it should be very similar to a residential one, in that their reason for being is to manage and maintain the common property. They don't actually run any other kind of business. They're engaged in managing and maintaining the common property, which should then put them into the category of a person conducting a business or undertaking that also manages and controls a workplace. And there are quite specific duties there, but again, they're very limited. We don't have the whole scope of other potential responsibilities that you might get from the primary duty of care, which is to conduct inductions for people coming to the site, to have policies and procedures and those sorts of things, because in a nutshell, the business that you're running is just really controlling, managing and controlling the workplace. That becomes a workplace from time to time. It's not even a full-time workplace. In the most circumstances, it's only when work's being carried out that it ever sort of falls into that category. So, they must assure as far as reasonably practical the workplace and the means of entering and exiting the workplace are without risks to health and safety to a person. So that's, I think, one of the primary aspects of what non-residential strata companies will be doing. Again, the idea, the minute you employ somebody, so you engage a worker as an employee, you have a whole bunch of other responsibilities in terms of policies and procedures for the way in which they conduct their work, safe work method statements. There's lots and lots of additional responsibilities that you need to undertake. So that's a big step. And if you do have that situation, then there'll be other things that we would need to discuss, but it's quite in-depth and quite specific. So you can't say that we need to do steps A to Z for all strata companies, because there might only be A to F for a particular one. So it comes down to what you do, and then how you do it, what tools you provide, and all of those sorts of things. So again, if you're employing somebody, that then becomes quite specific, and you'd need to engage somebody to help you out with that, I would suggest, very much so. So I think the main thing for me, when you were looking at Work Health Safety Act, is that it mirrors as well something called a duty of care. Duty of care is something that's in common law. It's not statute law. So common law is law that's set by judges, essentially, and they set precedents in cases that they go through. And the duty of care itself applies to everyone, whether you're in your own home, all the way out to an industrial complex. And at its most basic, it's a legal obligation to take reasonable steps not to cause foreseeable harm to another person or their property. So all schemes have this as a fundamental requirement. Now, what a lot of people don't necessarily understand is that's a proactive requirement. And so what you need to do is that you need to assure yourself as an owner, as a committee, that the common property is safe. It's not a defence under either common law or the Work Health Safety Act to say I didn't know or I wasn't aware. Essentially what you're doing is you're saying I don't have a defence. I'm just saying I'm ignorant of the facts with respect to the maintenance of the common property. And that's something you don't want to be saying at all. And essentially, you have that responsibility to ensure that it's safe by going out and looking, by maintaining the common property as best you possibly can, by taking advice. If somebody says that they slipped, do something about it. And we'll go through a little bit about that as well, but that duty of care sits there. So as far as I see, the next steps for most residential or even non-residential schemes is to see if they're a duty holder. So are you a PCBU or not? If you're not, then you don't need to worry about the primary duty of care and the responsibilities that come with that. So that's most of what you need to do. And then in what context are you a workplace? I think that's very important. So it's maintaining common property. That's what you do. And then next you have to figure out how you're going to discharge your obligations. So in the first instance, maintain the common property. I think I might have said it a few times. I hope I'm not pushing the barrow too hard. But to me, that's the most important point. Maintain your common property. Not a lot of bad things happen when you do that. Now, you've got building codes. Those building codes are there to provide you with a base to start from, and then maintaining it from there should be quite straightforward as well. If you don't do anything in terms of any kinds of inspections of the common property, then you're going to find it difficult to actually maintain the common property because you need to have a before and an after. You need to be able to gauge how the building is aging. You need to understand that there's rust here or everything has a life, and you need to just make sure that you're looking after that. So it's difficult for me to say go out and do a safety report because I'm selling safety reports. But again, that's the process. Go out and have a look at your common property. And that's an owner responsibility. What's really, really important is that owners can't transfer their liability. They have that liability and that stays with them. So if you engage somebody as a third party to assist you, that's fine. They can then do most of the heavy lifting, but then when they come back to you and say, these are the sorts of things that we need to talk about, you need to first satisfy yourself that that's correct and accurate, and then you need to do something about it. And I think it's really important to understand that regardless of whether I tell you to put up a handrail or not, the way that safety legislation works, particularly with that duty of care, is that you should know that there is a handrail missing. So whether I tell you there's a handrail missing or not, you still have a duty to make sure that there was one there in the first instance. And I'll go through a little bit of that in terms of some examples a little bit later in the second half. As I said, I'm a little bit over time as well. So the way I see it is that there are two things that you need to do from my perspective. The first is when you're maintaining the common property, you do a 10-year plan. The 10-year plan sets out all of your assets. It gives you timings as to how old we think the paint is, when it next needs to be done, how much we think it's going to cost. That sets your levies in your reserve fund. So now I have some funding, and that's great. That's for the longer term items. That will help me maintain the common property. And then when it comes to the, so that's the non-routine items. So when it comes to the routine items, things like have your fire extinguishers been tested every 6 months? That's when you do a safety report, and it'll include those sorts of items. It'll go through and say, look, we noticed the handrail was either missing or it's loose, the second step's cracked. Those are the things that help you deal with those issues going forward. So it's not the funding side of things. That's basically just the short-term very routine stuff that you should be doing as well. And then I've got something that might answer a few questions right at the end. I call them safety myths. And so essentially, there's a few things that come in when we talk about safety that people bring up quite often, and there doesn't seem to be answers to them, or didn't at the time that the question was asked. So in the first instance, one of the myths is if a new code, standard or law comes into effect, I need to upgrade to comply with it. Generally speaking, that's rare that you need to do so. There are some examples, say with smoke alarms, or there might be with, say, pool fencing regulations, where it's retrospective. But in most other instances, it's not intended to be retrospective. And there's a piece of legislation, I always get a chuckle out of it. It's called the Interpretation Act in WA, and it's an act that helps you interpret acts. And its sole purpose is to put you to sleep. No, actually, what it does is it sets out how you're supposed to read acts. So it's an overarching piece of legislation. And when you look at Section 37, what it basically says is, if we bring in a new act, it doesn't mean anything that was created under the old act is repealed or made illegal. I think it's really important to understand that sits as an overarching principle in a lot of legislation, and it's helpful in sort of determining what you do need to do and what you don't need to do. Then we get from time to time people saying to us, but surely there's a code or a standard that provides instructions for this. Right, so we get a great deal of information about how something might be built. We get some information about how something might be maintained, and we get very little information as to how often. So it never really gets better as the building ages. What you should do, how you should do it, they're Marbo, the vibe of the thing. You generally set up principles, you find codes and standards wherever you can. If you can't, you do a risk assessment. And I think that's really, really important as well. The other one that I brought up was that safety responsibilities are proactive. So that means that I hear people say, well, if you find something, I'll have to do it. No, you already had to do it. Whether I said you did or didn't is a matter of my opinion, but the legislation is very clear. You need to make sure that the common property is safe, and that's your job. And then another one that comes up is putting up a sign will fix the problem. In safety legislation, there's something called the hierarchy of controls. So what it says is you can put up your sign after you've tried to eliminate the hazard, isolate people from the hazard, substitute in another pathway, let's just say, if it was a trip, or you must have followed through on those steps. And then you can say, right, well, I can't do any of those other things, so I'll have to put up a sign. You can't just put up a sign straight away. Things like saying slippery when wet. Did you try to do something about the tiles? Did you try to stop people walking there? Just putting up a sign saying slippery when wet might just be an omission of liability as opposed to anything else. Because if a person does fall, one of the first questions that gets asked is, what did the strata company do to mitigate that risk in the first instance? And if it's just put up a sign, that might not cut it. So I kind of rushed through and I just wanted to say that we're here to help wherever we possibly can in these sort of circumstances, happy to answer questions. We'll put out a copy of the presentation that I put together, so you'll have the foundation there to work with, and I suppose open to questions now. That's back to you, Nikki.
Excellent. Thanks so much, Marcus. That was great. Lots of information there to go through. And as you mentioned, we will be sending out a copy of the presentation. So that should come out to everybody later today with the recording of the session that we're in now. So you can share that with people who weren't actually able to make it today. So that would be great because there's lots to go through, obviously. And the other thing too that I'd like to let everybody know is that you did write an article for us. I think it was about a year ago now. We've had it up on the site and it was titled "The New WHS Legislation to be Introduced. What does it mean for strata?" And the article's had just under 3,000 reads already, but it's been quite popular. But we will provide a link to that article and send that out as well, so everyone can, they might have seen it. We did share it again. I think we put it out in March last year, then we shared it again at the end of the year because we were anticipating that the legislation would be coming out early this year.
Yeah,
then it's been pushed back to March and now it's been pushed back to sometime this year. So once again, we'll send the link out to that article and people can just touch up on that as well. So just on that point, do you have any clarification around when it's actually coming out at this stage?
No. I'm no more in the loop than most people, unfortunately. Yeah.
Okay, that's fine. We'll just have to wait and see what happens, and we'll try and keep everyone informed. And I'm sure if you hear anything, you can let us know as well, and we'll let people know that way. Okay, so what we'll do now is we'll jump into the questions. So we had some questions, obviously, that were submitted to us before the event, and I've shuffled these around a little bit, Marcus. So I hope that's okay with you. But yeah, just to make things interesting for you. But I might start with there was one that came in from Fran, and that one was, I'd like to know what and you have covered some of these, but we do find that when it's a practical question that comes in, it just helps sort of clarify some of the points that you've mentioned during the presentation. So yeah, Fran, I'd like to know what the duty of care of a council of owners is with respect to ensuring the physical safety of owners on common property, specifically how that relates to the issue of other lot owners and their visitors speeding on common driveways, past private driveways that have very limited visibility in either direction, and putting other owners at high risk of serious, if not fatal, motor vehicle accidents. We have a speed limit on the common driveway and have installed speed humps, but many vehicles ignore the speed limit, thus endangering other lot owners. Is this a WHS issue, and what can a lot owner do about it, and what should the council of owners be doing to mitigate the risk?
So very broadly, if you're a residential strata company, then it's not generally going to fall under the WHS legislation. Having said that, one of the things that we commonly do, and this happens everywhere, is put up traffic mirrors to try and help mitigate the risk so people can see things coming. If you put up speed humps and you put up a speed signage, and sometimes you put up, combined with that speed sign is something to say shared pedestrian access, you're doing as much as you possibly can as well. If you have a notice board, or if your council is quite active, you can also just put bulletins out to people every now and again, just say, look, please do slow down. It's a shared access way. But again, unfortunately, what they say in safety is that there's no legislating for stupidity. You just can't stop people doing things. And particularly in a strata company where there's no hierarchy. So if you're in a standard business, there will be a person that's the boss, and then they have subordinates, and there's a chain of command. You can say to an employee of yours, do this, don't do that. It doesn't work in a strata company, unfortunately, particularly when there are owners, there'll be tenants. Tenants are generally not, how would you put it, they're dealt with by the property manager. So what we end up having is a strata company or a council writing off to a property manager to ask their tenant who lives right next door to do something, because people might get offended if you talk directly to the tenant. So it becomes quite difficult that way. So all you can do is do everything you can to mitigate the risks that are associated with that. So traffic mirrors are another great way of doing that. And yeah, just keeping people aware of the fact that it's a problem. And unfortunately, that's it. There's nothing under the Work Health Safety Act that will help in that situation. Unfortunately, you can't go to WorkSafe WA and say, find these people.
Okay, thank you.
Right.
We had one from David. When declaring wages estimations and actuals to insurers, is it just that which applies to the common property arranged by the strata company that needs to be declared, or are all works done by lot owners needing to be declared as well? For example, would a lot owner's kitchen renovation need to be declared?
So I'm fairly sure this will sit under requirements in terms of insuring buildings. What we do is we advise that the lot owner should always write to the strata company to say, or the manager to say, I've made renovations to my lot. The improvements amount to $100,000. Please note this on the policy for the building, if that's how this particular strata company is going to be insured. From what I understand, it's not an absolute requirement. It might be a bit of a pain to document, but it's always good if that's the policy, so that you become aware of the improvements and they're documented somewhere. It'll still be up to the owners to ensure that they're actually maintaining their lots and being insured properly for their contents and those sorts of things. But yeah, when we do insurance valuations, upgrades, if they're substantial, we try to get information about, but generally we get very little of it because there's no record. So we have to make assumptions in terms of a rate per square metre that we might do. If we see the size of the lot being expanded somehow, when we look at it from a satellite view, we've got a great little program that helps us out with that. We can see that, you know, it was on the plan 100 square metres, now it's 130. You know, there's an addition that's been made, and when we see it on site, we'll say, oh, it's brick and tile, and we'll apply something for that. But otherwise, what goes on internally, really, if the owner doesn't tell you, it's hard to know. And that's particularly the case with commercial or industrial properties. They might put in mezzanines, and how would you know? So yeah, yeah. The unfortunate, I suppose, side effect of that is that some people then get into arguments about whether it's fair that they should be paying more or less for their property as opposed to somebody else's property. And look, those arguments essentially go nowhere. You have to be insured, and that's for everyone. And the entitlements generally sort that out too.
Okay, we had one from Judy. Our approximate 50 lot strata has a strata manager. We rely on the strata manager to organise contractors to carry out work on the property. Can we assume the strata manager has carried out their due diligence when supplying contractors? And do strata managers have some type of compliance checks in place when organising workers?
I suppose the short answer is that they should. And I'm aware of a lot of managers that do. And they're quite straightforward in that, are they insured? Are they qualified for the work? Sometimes that's a necessity. So if you need electrical work done, they need to be an electrician. So they need to be licensed. And above and beyond that, there's not too much more that you can actually do. So insurances and licensing, I think, are very, very important aspects to it. And most management companies that I'm aware of do that, just to make sure, because, you know, I've been in a situation where we had a plumber / electrician replace a hot water system in a unit. And fairly shortly thereafter, the manager was getting phone calls that people were getting electric shocks whenever they used their tap. And it turned out that the plumber / electrician, who was actually neither, had earthed the hot water system to the copper pipe running through the entire building and not done a great job of it. So, yeah, you can run into those problems. And look, what it really comes down to is just having that conversation with your manager and basically saying, look, what sort of checks do you do? But the issue is that if a owner decides to do it themselves for some renovation work, all you can really do is to sort of have some rules around how renovations are to be carried out, and hope that people are doing that, and just keep reminding people as well that they can cause problems by themselves too.
Helen has asked, a 15-lot strata is zoned hotel motel in the city of Albany. The scheme consists of 12 lots of 2-storey units with short stay holiday accommodation of a maximum of 3 months stay, plus 1 bed and breakfast property with a residential owner and 2 vacant blocks. Would this scheme be considered solely commercial? And if so, which sections of the Act apply for maintenance and duty of care obligations?
So what I would go back to, if you can, is to find a document of registration or a certificate that actually says this is it's under the Building Code of Australia. It basically says this is the use that this building is set out for. So it'll say it's a Class 1, which is generally a home, a Class 2, which is, say, townhouses, a Class 3, which is multi-storey, and then you've got 4s all the way up to Class 9s, which deal with different levels of either healthcare and commercial properties, or 7, which is, say, car parking. So that's where you start, because it's if you have a look at a lot of councils, working from home is not. They don't deem that as to be working outside of what a residential property is designed for. Now, conducting a business from home where you have lots of people coming and going, that will then usually result in a complaint to council, and the council will come out and investigate, and they might say to you, sorry, you can't do that. So letting a property in a commercial sense, say holiday letting and all of those sorts of things, doesn't necessarily change the zoning of the property from the initial application and approval process. So it's very important to sort of start at what documents you can, and then again, just seeing if it's in a residentially zoned area, it's probably residentially zoned. If it's an actual hotel, then it will have a different zoning, and it'll then be a commercial, which means non-residential, which means it'll be a person conducting a business or undertaking, and it'll then have responsibilities to maintain, responsibilities with respect to access and egress to the common property, and probably certain other responsibilities if there's an employee on board as well.
Okay, thanks so much, Marcus. Now we're coming up to the end of the session. We have got a couple more submitted questions, but I might just leave those for the moment because we've had a few other ones that come in that might a little bit more pertinent to what we spoke about today.
Yep.
So one of them was, and you have mentioned this, but I thought that I would pull it out because it is something that I think a lot of people will ask questions about, and that has anything changed with volunteers working on common property?
And the short answer is no. So that volunteers are a worker, and so that's more clearly defined. So what they'll say is if you have responsibilities to workers, then it'll clearly define what those responsibilities are. So if you're a person conducting a business or undertaking, you will have responsibilities with respect to volunteers. If you're not a person conducting a business or undertaking, then you won't, is the, I suppose, the shortest answer there. That said, a lot of strata companies that I'm aware of throughout the various states have this debate as to whether they should have workers' compensation insurance. And my answer to that question is yes, every time. Just do it. It's not a lot of money, and it protects you because there are deeming powers that the relevant authorities have to say, we might deem this person to be an employee, even if you think you've engaged them as a contractor. And as I said, I don't believe it's a lot of money, and there's a lot of peace of mind that comes from it.
Excellent. And then we had another one from Gail, and she had asked also if the strata committee are the strata managers of the strata property, are they then classified as an officer or not?
No, again, because unless the strata committee, so there are some strange titling provisions. So I'm not quite sure what they're called in WA, but they have what is called a company title. That would be different because in a company title, it's set up as a proprietary limited, and you don't buy a property, you buy shares which correspond to a property. So if you have something like that, yes, then you're going to have responsibilities that go with that. But being self-managed, if you're a residential scheme and you don't employ somebody as an employee or engage somebody as an employee, then you're not considered a person conducting a business or undertaking. And if you're not a company, then your officers, being the committee members, aren't deemed to be officers with respect to the work health safety legislation. So there shouldn't be issues there.
Great, thank you so much. I know there were things that you had mentioned during the session, but it's great to get just that really quick, clear clarification at the end on that. So thank you very much. So what we might do, we're just about to finish. So just to say that if you did submit a question either via the chat today or we didn't quite get to it from a submitted question that you'd sent in previously, please jump onto our site. There's the Ask a Strata question page, and I'll include a link to that in the information that we send out as well in case anyone has any further questions. And you can submit the question through that avenue, and then Marcus has agreed, which we're very grateful for, yet to provide some responses for us. So we should get those out to you over the next few weeks or so. And we'd just like to say a very big thank you to you, Marcus, for providing the clarification around the legislation that we've got coming this year. And I know that QAA Group regularly appear in our state-based magazines, and also you're a regular contributor to questions about WHS and compliance and safety that we push out to our audience all the time. So we thank you very much, Marcus, for QAA and for your continued support and for taking the time today.
Oh, that's absolutely my pleasure. And we are a national company, so have work, we'll do it, and we'll also travel. I mean, it's such a hard thing for me to do, to come over from the East Coast to WA and swan around and do a little bit of work. It's so happy to answer questions, even if you don't necessarily do work with us at the moment. If you have a burning question, you can ring. We've got a few subject matter experts, as they call them, in our company, and they're more than happy to help as much as they can. The one caveat that I've got is if it sounds legal, get a lawyer. If you have a structural problem, get a structural engineer. If you have a roofing problem, get a roofer, because that really is central to the work health safety legislation as well. That it's very, very important that you consult the people that can fix the problems or that can tell you what the problems might be. Don't, if you've got a problem about whether a balustrade is too high or too low, call a certifier. Task them with determining whether it met the code of the day. It's really important that you do those sorts of things because they're really simple steps, and you get a very definitive answer which you can then rely on, as opposed to asking a generalist who may or may not provide you with something that's of use.
Definitely. Thanks so much. And funny you should mention about coming over to WA as we open our borders to everybody today again. So we've joined the rest of Australia, which is really great to see. Thank you so much. Thanks, Marcus. And it was a pleasure. Pleasure having you. Thank you to everyone who's joined the session today. We're really grateful for you for taking the time. I know this is the first one we've had for a while that's been on a good time zone for WA, and we're sorry about the early mornings that we usually have you turn up early for sessions, but it's great that we've been able to bring this to you today. So we thank WA as well for their support and for joining us when we have these state-based educations. So we'll hope to see you again at a session in the future, Marcus, whether it be a WA or a national or a different state session on a different topic. And everyone keep an eye out for what we've got coming up in the newsletters that we're sending out in magazines, and we'll keep you informed. All right, thank you so much. Thanks for your time.
Thank you.
Thanks. Bye.
Bye.